Thank you very much. Thank you all for inviting me. It's a great pleasure to be back here in Ireland again. I haven't been here for a while. I was for a while their external examiner for your competitors in Limerick. It's nice to see one or two people from Limerick here as well. And from other universities that I know from other trips I've made in the past. The Masaryk University in Brno, I've been there a couple of times, and the University of Glasgow, or Glasgow more generally, which is my hometown. Now, last time I gave this talk, I gave it a trial run in New Zealand, and it took me 40 minutes, so I'm hoping not to... That wasn't the right thing to press, was it?
Yeah. The next
Oh, yeah? Okay, let me just see. Yes, okay.
Yeah.
Wait a minute. I need to get it back, though, to full size, don't I?
Yeah.
Wait a minute. I should have pressed the space bar rather than the... Oh, it does matter. I'm very keen on getting my graphic design right. You see?
And
there we go. Just want to get it.
Slideshow. Oh, it's that new one.
From beginning. Yeah?
Yeah.
Is that right? There we are, you see? And then I have to use the space bar. Is that right?
I think anything.
Anything will do? All right. Well, we'll see. You may have to come over again. Okay, so yes, this took 40 minutes, so I hope I can do justice to it in a shorter time, but we'll see. I wanted to really talk to you about this young man, Jean de Menezes, who was killed in London in 2005. And I'm going to begin by telling you something about what happened, and then I'm going to raise a few points. One of them is more of philosophical interest, and the other two are about the law specifically. They're doctrinal points. So here's the story. On the 7th of July 2005, there were four bombs went off on London transport. 3 were on the tube and 1 later on a bus. The 3 that went off on the tube went off about simultaneously at 8:50 in the morning, a very busy time. And the later one was set off on a bus lit by a young man who had been apparently in two minds about whether to participate in the events to begin with. 56 people died, including the 4 carriers of the bombs. That's a picture of them entering the railway station in Luton to travel down to London, and there's been some interesting contention on the web about whether this is really possibly them, because apparently the train that was about to leave then was cancelled and they couldn't possibly have got to London in time. So that yields all sorts of conspiracy theories and so on. I'm not interested in that. This is a photograph of the scene on the tube when a train was being evacuated after a bomb had gone off on a train in front of it. And that's the scene outside the tube at Russell Square, near where one of the bombs went off on that morning. I was around at the time and I was on the tube when it all happened, and so this all has a lot of personal resonance for me. The 21st of July was the next major event. 2 weeks later, 4 more young men were on the transport system with rucksacks packed full of fertilizer explosives. They detonated their bombs, but none of them went off. Only the detonators did. There were no injuries, and the bombers made a run for it. And so there was a manhunt. These guys were being sought after. The next day, the 22nd of July, the police and 1 or 2 people from the special forces as well were staking out a block of flats in Tulse Hill in South London. And the reason for that was that one of the bombers had fled, leaving the rucksack behind, and in it was a gym membership card, and the gym membership card was traced to this address. The gym held this address on file, and the police were staking it out to see if they could identify and intercept this young man. It was a rather strange thing to be doing, because they could probably have checked quite quickly and easily to discover whether he was there, but they didn't. They staked it out from a van instead outside. And at 9:30, an officer codenamed Frank sent in a report that it would be worth someone else having a look at a young man who had just exited the building. And the reason why he wasn't able to take a photograph or to give a more positive identification was that he was having a pee at the time. and he just caught it out of the corner of his eye. And that was the beginning of a catalogue of disasters that led to the event that I'm going to talk mostly about. Because from here on, identification was of the essence, but was very badly handled by the police, and that was subsequent investigations established just how badly that was handled. It turns out that this was a young man called Menezes, an electrician. He was on his way to work. Contrary to some reports in the papers that were released by sources unknown, he wasn't wearing a bulky jacket that looked like it might contain explosives. He wasn't carrying a bag full of wires. He was just dressed normally in a denim jacket. And all the same, Gold Command, on the basis of Frank's report, Gold Command was the central command post at Scotland Yard, the police headquarters, authorised pursuit and surveillance of Mr. Menezes on the hunch that he might be one of the people they were looking for. And the officer in charge of Gold Command that day was a very reputable officer, Commander Cressida Dick, who was later exonerated of any personal culpability by a jury in the inquest. I just wanted to make that clear, because the story I'm about to tell is a story of collective failure more than of individual failure. Although undoubtedly there must have been some individual failures in it, the story is really one of collective failure. So Gold Command sent its surveillance, undercover surveillance squad on the trail, also known as the Keystone Cops, because the succession of messages they sent back were totally confused. At 9:39, a member of CO12, the surveillance squad, said that it was good possible likeness. At 9:42, may or may not be suspect. That's a message that they hardly needed to send. And at 9:46, not identical, which sounds like a negative identification. This is just a selection I picked out of the radio messages that went back to Gold Command. What was happening while these messages were being sent back was that a firearms squad, CO19, was on its way to the scene, but nobody knew where they were. And it wasn't clear at any time whether they were about to show up or not about to show up. And young Mr. Menezes took the bus to Brixton with an officer from CO12 on board with him. And he changed buses at Brixton because he was going to catch the tube from Brixton, but Brixton station was closed because of another scare, an unrelated scare. He got on another bus, and this was thought by the surveillance people to be suspicious. Since everybody else was doing the same, it's hard to know why. And he went to Stockwell. And meanwhile, CO19, the firearms officers, were on their way to Stockwell. And the really fatal mistake in the whole thing was this, that Cressida Dick, the officer in charge at Gold Command, didn't expect CO19 to make it in time to follow Mr. de Menezes into the tube. They had been supposed to take over, but they weren't there. And she asked the surveillance officers to continue into the tube. But CO19 showed up just as they were about to enter into the tube, and they said, okay, you can do it instead, with no intelligence. And so CO19 didn't know what they were doing, didn't know about any of this equivocal identification evidence, and their radios didn't work in the tube. All right? So that's an extremely bad situation, as you can imagine, because they're heavily armed officers, and they assume naturally enough, because they've been sent to this place, that they're dealing with a very severe situation. And this is what happens. Mr. Menezes gets on the tube as usual, well, not quite as usual, because he's gone to a different station, but he's followed on to the tube by the officers from Firearms Squad, and he's killed by them. They fire at him 11 times, and he's hit 7 times in the head and once in the shoulder. And that's the scene of his body on the tube. Now, there was lots of disinformation and misinformation in the papers after this. Some people said he leapt over the barriers to get into the tube station. Not true. He used his Oyster card. It was later proved to open the gates. It was the police who leapt over the barriers, and they were misidentified as being the suspect. Often happens when members of the public are watching what's happening in a police chase situation. He was said to have run down the escalators, but in fact, CCTV footage, such as it was, later showed that he'd only started to run when he saw that the train was about to leave, as we all do. So the only information on the basis of which this young man was killed was really the muddled chain of poorly communicated information that led the SO19 firearms officers to think that they were dealing with a person who'd been positively identified as one of the bombers from the previous day. didn't even look like him very much. But as you can tell from the way it all happened, that didn't really matter. Because really the only serious identification they had was Frank out of the corner of his eye when he was taking a pee. You can imagine that quite quickly things were handed over to our Independent Police Complaints Commission. It wasn't as quick as it should have been because the Metropolitan Police refused to let the Independent Police Complaints Commission have access to the scene, saying that it was all far too serious for a Police Complaints Commission to investigate them. And so there was a great flurry of letters, including the Home Secretary and other people, trying to justify the decision of the Metropolitan Police to make it their own crime scene. But in fact, it was handed over to IPPCC quite quickly, and they conducted the first of two inquiries, Stockwell 1 we call it. The report was published and submitted to the Crown Prosecution Service on the 19th of January 2006. Then there was another inquiry, which was instigated on the 14th of October 2005. The reason why there were two inquiries was that the first one was into the events that led to the death of Mr. de Menezes. The second was into the misinformation, disinformation, and so on that was associated with the aftermath of his death. On the 17th of July 2006, so that's basically a year later, the Independent Police Complaints Commission had passed their report to the CPS, and the CPS accepted the recommendation that the Metropolitan Police Commissioner, as an official, should be prosecuted in his official capacity, effectively prosecuting the service as a whole for breaches in the Health and Safety under the Health and Safety at Work Act of 1974, which is failing to take sufficient care for Mr. de Menezes' safety. But there were to be no individual prosecutions. That was what the IPCC had suggested and what the Crown Prosecution Service agreed. In this period, in October to November 2006, the Metropolitan Police were prosecuted and they were convicted and fined, and it was the jury who made a point of saying that they didn't wish their verdict of guilty to be thought to be associated with any personal culpability for Commander Dick, who was running Gold Command that day. On the 22nd of September 2008, it was a long time later, but a lot of things had to be done before it could be done. There was an inquest, and on the 12th of December 2008, an open verdict was returned. This was because the coroner advised the jury that it wasn't open to them any longer after the decisions of the Crown Prosecution Service to enter a verdict of unlawful killing. An open verdict was the most severe reprimand that, as a jury, they were entitled to issue to the world at large, which is what they did. Now, I wanted to introduce you to an important legal doctrine, which goes some way to explain the decisions of the Independent Police Complaints Commission and the Crown Prosecution Service. And I'm going to introduce you to it indirectly by introducing you to a more general doctrine, which is the Citizens in Uniform doctrine. According to the Citizens in Uniform doctrine, by default, the police have only the duties, the powers, and the permissions of ordinary members of the public. I say by default because, of course, it's open to Parliament or the legislature to vary that by making specific provision for the police to have other duties, powers, and permissions, and so they have from time to time. But by default, the police are citizens in uniform. That's their common law position, and that's connected with their history. We didn't have in the United Kingdom a police service of an official kind until the 1820s. Before that, there were parish watchmen and a miscellany of people who had the office of constable, but the office of constable was conferred by a sort of training rather than by holding a duty. Oh, beg your pardon. Rather than by having a statutory position. So by default, that position remained even after the establishing of a statutory police force by Peel in the 1820s. And it remains the default position today, which means that exceptions have to be carved out by legislation. And there's a certain amount of confusion in the literature about all of this in recent years because of changes in the way public law works in the UK. We've had huge development since the 1950s, really, of judicial review, which has led to a lot of new discussion that would have been completely unimaginable in English law before that, of the difference between public bodies and private individuals. And the two propositions that I've put up there, everything which is not prohibited is permitted, and public authorities have only powers conferred on them by law, have often been muddled up so that it sounds like public authorities are in a different legal position from private bodies, and the citizen in uniform doctrine has been abolished. Why? Because it's sometimes thought that the second proposition means that where public authorities are concerned, everything is, which is not permitted is prohibited. It's sometimes read that way, to suggest that the presumptions about permissions and prohibitions are reversed in the case of public authorities. It doesn't actually say that, and nor should it be read that way. The first proposition applies to public and private bodies alike. Everything which is not prohibited is permitted. So public authorities can do what I can do and you can do lawfully. The second proposition is about their powers. It's a different thing from their permissions. Their abilities to make a legal difference by issuing orders or decisions. And of course, in that case, they need to have the power conferred on them by law. So there are some interesting issues in this area of public law that are relevant to the de Menezes case, because there are interesting questions about whether arresting people is a permission or a power, and so on. That's not the main thing I want to focus on, though. I want to focus on the general proposition that still holds the citizens in uniform doctrine. So here's a quote from Vice-Chancellor McGarry confirming effectively the citizens in uniform doctrine, confirming that the same rule applies to public officials as applies to private bodies. He says the reason why a search of premises, which is not authorized by law, is illegal is that it involves the tort of trespass to those premises. It's a pretty straightforward explanation of the position of public officials, namely that they do things illegally when it would be illegal for them to do them if they were private citizens. All right? If it would be a trespass for me to go in and mess around with your stuff, then by default it would be a trespass for the police to do that as well. That's the reason why their acts are unlawful. There are extra additional things piled up on top of that by statute, but that's the basic position. And then here's one of the consequences of this in a case called Rice and Connolly in 1966. And this is about the special relationship that we have as individuals with the police when the police purport to do things to us. And this is Lord Parker, then the Chief Justice. He said, it seems to me quite clear that though every citizen has a moral duty, or if you like, a social duty to assist the police, there's no legal duty to that effect. And indeed, the whole basis of the common law is the right of the individual to refuse to answer questions put to him by persons in authority. He meant as if they were not in authority. Right? So the idea was, if I came up to you and said to you in the street, who are you? You would be entitled to say, well, who are you to ask me? And if a police officer comes up to you and says, who are you? You're also entitled to say, who are you to ask me? And it's no answer for the police officer to say, I'm a police officer, I can ask you what I like. Because you can then say, I don't care. That's the position taken in Rice and Connolly, subject, of course, to statutory exceptions. And here's a reiteration of it by Lord Diplock in 1982 in the famous case of Albert and Lavin. The well-established principle that to detain a man against his will without arresting him is an unlawful act and a serious interference with a citizen's liberty is subject to an equally well-established exception, not confined to constables, right? Applicable to you and me as well, that every citizen in whose presence a breach of the peace is being committed has the right to take reasonable steps to prevent it. So there's a rule and there's an exception, but both the rule and the exception apply even-handedly to officials and to non-officials. And here is a very interesting and relevant application of the proposition, which is a case, infamous case, involving a rookie soldier in the Troubles in Northern Ireland in the early 90s, who shot and killed a joyrider, and much to his disadvantage in the subsequent proceedings, the shot that killed the joyrider was fired from behind after the car had gone past him. And so he was charged with murder, and he argued self-defense. And there was a certain amount of interesting legal debate about whether he could benefit from a plea of excessive self-defense that might reduce murder to manslaughter. That wasn't known to the law at the time, and the House of Lords agreed that they weren't going to start creating that now. And this is what Lord Lloyd says about the general proposition. He says, in most cases of a person acting in self-defense or a police officer arresting an offender, important that we keep that additional case in mind, There is a choice as to the degree of force to be used, even if it's a choice which has to be exercised on the spur of the moment without time for measured reflection. But in the case of a soldier in Northern Ireland, in the circumstances in which Private Clegg found himself, there is no scope for graduated force. The only choice lay between firing a high-velocity rifle, which, if aimed accurately, was almost certain to kill or injure, and do nothing at all. The point is whether the offence in such a case should, because of the strong mitigating circumstances, be regarded as manslaughter rather than murder. So to hold would be to make entirely new law. Under existing law, the trial judge had no alternative but to convict of murder. And what's interesting for our purposes about this dictum, or this set of dicta, is twofold. First of all, the circumstances are strikingly similar. There's a choice between lethal force and no force. There isn't a via media that's open to the officers involved. It would have been pointless on that tube train to just injure a bomber because he could still have detonated his device. They had to decide whether to kill him or to let him be. And secondly, it's an application to police officers as well as to soldiers and everybody else of the general doctrine, which is that if you don't fall under self-defense and get a complete acquittal, then you fall under murder. And I'm stressing that because I want you to understand that if the common law were to be applied to these officers on the tube train, it would have to be applied in the following way. We would have to ask the question, were they murderers? Indeed was a question that was asked at the time. And the only way that it would have been open to them to escape from the murder charge would have been like Lee Clegg in Northern Ireland in 1992 to plead self-defence or reasonable force in effecting an arrest, both of which are common law defences available in principle to everybody because there can be citizens' arrests as well as police arrests. One thing you might think that differentiates the CO19 officers from you and me is that they were lawfully carrying weapons. It's a very interesting question that I urge you, if you're working in this area of law at all, to think about why it was lawful for them to be carrying weapons, why they weren't guilty of the offence of carrying an offensive weapon. And it's actually much more obscure than you might hope. You might hope that it was very clear why these officers were allowed to wander around with guns, but it's not at all clear. That's why I've said that even the powers that they had, or the permission they had to carry weapons, is only under the general law. They had to show that they were justified in carrying these weapons under the Prevention of Crime Act 1953 and the Firearms Amendment Act 1997, which requires them to be licensed by an officer of the police exceeding the rank of superintendent. You think to yourself, well, they work for an officer of the police exceeding the rank of superintendent, so shouldn't there be some other person whose job it is to license them? That's an interesting question. But whatever means they may have had at their disposal to kill, they didn't have an extra permission to kill. They had no permission to kill anyone that the rest of us wouldn't have had in the circumstances. So if it happened that I was lawfully carrying weapons of this caliber on the tube that morning, which is possible if I had been correctly licensed and was on my way to some event involving firearms, then I would have been permitted to do what they would have done if all else were equal. You've got to focus your mind on that before you think about how much permission there should be in this situation. You have to think to yourself, well, in principle, the permission we grant in this situation is granted not only to the police but to the rest of us as well. We have to ask ourselves this: how would you react? How would I react? How would any of us react if a person who was not a police officer had done what was done by CO19 in a purported effort to stop a suicide bomber? Say, if somebody had been chasing you down the stairs, let's just grant that bit of the story, would you have turned around and said, "What do you want? Can I help you, officer?" Probably not. And what's more, would you have done it if the guy looked like this? Right? This is a photograph taken that day. And this is the most shocking truth about the events of July 2005. That for a brief period, and this photograph was taken on the day after the event, but this was also visible on the streets before. I was there at the time and I witnessed police officers dressed in this way with no identifying marks other than the fact that they were carrying submachine guns. This is the most shocking discovery from this, that it's possible for police officers to be indistinguishable from gangsters. And so the citizens in uniform doctrine then has a special irony, which is that these citizens were not even in uniform. All right? So you have to think about how English law could have reached a position where that scenario there is possible. So, how should Mr. de Menezes have reacted to a person like this? And I'm assuming there that he did have some reaction. Actually, the real story turns out to be that he didn't even know he was being followed. But suppose he was being followed by this guy. Do you think he would have run, or do you think he would have stopped and had a discussion? So that's trying to address your mind to this question, which I think is important. Is it right to criticize anybody in this situation for not having a natural instinct to cooperate? And the story that was told of Mr. de Menezes in what turned out to be disinformation at the time was that he was a baddie because he wasn't interested in cooperating with the police. And I must say that as a Londoner at the time, I wasn't very interested in cooperating with them either. They looked like a bunch of gangsters to me. Now, okay, that's a little bit of general constitutional law. Here's an interesting little bit of theory for you. You might wonder whether the citizens in uniform doctrine is right. And I know that in everyday life, many people think it's right. It's wrong, but for the following reason. They think it's wrong because we ought to think of the police as different from the rest of us. And I agree with that. I think we ought to think of the police as different from the rest of us. But I don't think we ought to think of them as different from the rest of us in the direction in which is commonly thought. I want to suggest that the citizens in uniform underestimates the potential evil of the police activities on those days, not overestimates them. So the instinct in the newspapers is to say, well, they're the police and we have to give them extra latitude. My instinct is to say they're the police and we have to really be strict about the latitude we give them because they're the police. Additional pressure has to be put on their behaviour beyond what we would put on the behaviour of ordinary folk. They're trained, they have information, they're specially equipped, it puts special responsibilities on them. They're also supposed to be people of high character. If they can't manage it, then it shouldn't be something that we allow as a ground for extra latitude. That's my thought. And I want to begin by explaining why it might be morally problematic to be killed by the authorities, especially morally problematic. I'm going to defend that proposition. All else being equal, it's morally worse to be killed by the authorities than by others. When I wrote this on the web at the time, somebody said, "You're dead either way, how do you care?" And I pointed out the word morally, right? It doesn't feel worse, you're dead anyway. But it's morally worse, because how bad things are morally isn't totally a matter of how you feel about them. All right? So, I want to explain why, and I want to explain why by drawing your attention to a completely different case. The Aviation Security Act case of 2006 in Germany, which was a case in the Constitutional Court that invalidated Section 14 of the German Federal Aviation Security Act of 2006. What did that act say? It said that the Air Force, the German Air Force, could shoot down a hijacked civilian airliner with innocent passengers on board to avoid an imminent risk of its use as a missile against a target on the ground with further loss of life, including the loss of life of those on the plane. And the German Constitutional Court said, no, we can't have that legislation in Germany. It's a violation of the basic law because the people in the plane would be treated as mere objects by the Air Force if they were shot down. Now, I don't really understand that reasoning. I don't see how it makes sense. Because aren't they already being treated as mere objects by the hijackers? And is there any sense in which they're being treated more as mere objects if they're killed to stop the injuries on the ground than if they're killed to enable them? But you might think you're more of an object if you're killed to enable than if you're killed to stop, especially if your death is a side effect of the destruction of the plane. But why would it be thought worse, I want to know? This is what I want to ask the German Constitutional Court. More of an affront to human dignity to be killed by the Air Force than by the hijackers. That's the choice. All right? Well, here's one suggestion. This is my suggestion, actually. It's not just one suggestion, it's the one I want to propose. There's an aggravating betrayal involved when you're killed by people who are supposed to be your protectors. And I'd like you to think about the comparison with domestic violence. That there's an extra element of moral degeneracy involved in the case where somebody who sets themselves up as the person who looks after you and who cares for you and who's investing time and energy and thought in your life turns against you and kills you. Now, turns against maybe a slightly pejorative way to put it, because you might say, no, I'm turning against Mr. Menezes, but I'm using it to capture all those cases in which you become the target instead of being the object of protection. And that leads to a further suggestion, which I also want to endorse, that the betrayal is especially aggravated when there's nobody else to turn to, when those who do the killing are the final line of protection. That's also an analogy with domestic violence. It's very important to understand the analogy that in domestic violence cases, it's not just that you're being betrayed in the sense that the person who is supposed to love you and care for you is turns into your attacker, but that person is also, for your purposes, for practical purposes, very often the last line of defense. There's no practical mode of escape. It's one of the things that's often misunderstood about domestic violence. People think it's dead easy to get out. You just turn the key in the door and go, but it's often not. There are children. It's not clear where you would go. It's not clear what other protections are available. There often aren't authorities who are standing outside ready to come in and help you. So that's a final line of protection argument. And so the consequence of these two thoughts, that it's an aggravated betrayal when you're killed by somebody who's your protector, and especially if the protector is the last line of protection, is that we should rather just be murdered than murdered by somebody with a special duty to look after us when all else is equal. But then you might think, it's not true that all else is always equal. There are other factors to be factored in too here. And this is my last little bit of argument for you. Well, the first thought is the police and the Air Force and other authorities are defending us. That means the rest of us against terrorists. In that way, they're not like the domestic violence guys. They're in a different category because they're defending the rest of us against terrorists. You might say, terror killing is aggravated too. That puts them more back into the same ballpark in respect of the prima facie judgment. One kind of bad way to be killed is to be killed by people who are there to protect you. Another kind of bad way to be killed is to be killed as a way of terrorizing other people. And the police are, the Air Force are, the authorities are caught in the middle of these two kinds of evil. So although the authorities have a special moral duty not to kill, the authorities may also have a special moral justification open to them when they do it, ironically. So morality gives with one hand and takes away with the other. They can plead defense of others, where those others are also people to whom they have the same special moral duty. Other innocent people whom they owe a duty of protection to. But notice that's not the same as saying that the police didn't do any wrong to Mr. de Menezes. It's consistent with saying they did him a grave wrong and they owe him a posthumous apology, which indeed, in fairness to them, they gave. And they might owe compensation as well if he was a breadwinner or something like that. But it doesn't follow that they're guilty of murder, because it's one thing to wrong somebody and it's another thing to wrong somebody without justification. And so you might say that they benefit from a justification that was specially theirs because there are special protectors. Or do they? Well, let's assume this. If Mr. de Menezes had been the bomber that the police mistook him for, killing him as they did would have been justified. Let's grant that much. So then they do have the special justification. But this is the opposite case. If they'd known him to be the innocent person he actually was, killing him as they did would have been unjustified. So those are the two straightforward cases. Now we've got the case. Which way do the assumptions take us now? Do the police get the benefit of their mistake or not? If they mistook him for a bomber, is his case treated as more like the case of the bomber or more like the case of the innocent person? That's the choice. That was also one of the questions in the case of Private Lee Clegg. And English law says that they do get the benefit of their mistake. I'm not sure whether this is the case in Ireland. It was the case in New Zealand, when I was in New Zealand the other day, and I know it's the case in Australia, and it's also the case in Canada. But English law says that in place of the justification defense of others, the police officers in this situation get an excuse, mistaken defense of others. And an important thing about this is that it depends only on them having made the mistake, never mind why they made it. So this is a quote now from Gladstone Williams, which is the case in which this was decided. It was then upheld by the Privy Council in a case called Beckford. If the mistaken belief was in fact held, said the court, its unreasonableness is neither here nor there. It's irrelevant. Were it otherwise, the defendant would be convicted because he was negligent in failing to recognise that the victim was not consenting or that a crime was not being committed and so on. In other words, the jury should be directed, first of all, that the prosecution have the burden or duty of proving the unlawfulness of the defendant's actions. In other words, that it was prima facie murder. Secondly, if the defendant may have been labouring under a mistake as to the facts, he must be judged according to his mistaken view of the facts. Thirdly, that is so whether the mistake was, on an objective view, a reasonable mistake or not. Now notice that still the citizens in uniform doctrine at work. There's the same rule for the police as for you and me. Is it a good rule? Well, just look at the de Menezes case to form your view. It doesn't only make the negligence of the killer irrelevant, it makes the recklessness of the killer irrelevant as well. A very, very severe catalogue of errors amounting to recklessness isn't enough to deprive you of your protection of others or your self-defense plea. And that's inconsistent with the rules we adopt for other excuses in the criminal law. For example, duress and provocation. They require reasonable fortitude, reasonable self-control, and so on. So you only, in the case of those defences, get reasonable latitude. You don't get the latitude that you would give yourself by your mistakes. Why not reasonable attentiveness as well? That's the question that I think is thrown up most starkly by de Menezes' case. Now, it's very interesting that the Gladstone-Williams doctrine, that it need only be an honest and not necessarily reasonable mistake, has been overruled by statute in relation to consent in rape. I think rightly. But bizarrely, and I think pandering to people who want to be able to defend themselves in their houses against burglars, it's been preserved by statute in relation to defensive force. So in the same 2-year period, Parliament said, as to consent in rape, mistakes have to be reasonable, but as to the situation calling for defensive force, they still only have to be honest. And that's the reason why no homicide prosecution was possible in the case of Mr. de Menezes. The Independent Police Complaints Commission had to admit that its hands were tied by the law. They had to admit mistakes were made, but mistakes were made in self-defense or protection of others, and those mistakes are exculpating, not inculpating mistakes, even if they were reckless. And Gladstone-Williams made it impossible in law to inquire into the reasonableness of the police officer's beliefs, individually or as a group, about the threat posed by Mr. de Menezes, even if they were outrageously ill-founded beliefs. And that's a sorry situation for the law to be in. Why, we might want to know, has Gladstone-Williams been confirmed by statute in the wake of the de Menezes case rather than overruled? I wanted to end by drawing your attention to something in Geoffrey Chaucer. This is from the Mansiple's Tale. That's why I called it the Electrician's Tale. This was told in Southwark at the Tabard, about 1.5 miles from Stockwell Tube Station in about 1390. And I've put my translation on the right. Now you lie dead, no colour in your face, quite free of guilt, I'd wager with confidence. O reckless hand to do such awful wrong, O clouded mind, O sightless rage, so ill-advised as strikes an innocent down. O mistruster full of false suspicion, where were your sense and judgment? O everyone, beware of recklessness. Never believe without convincing proof. Strike not too soon, before you're certain why, and consider well and soberly, before you carry out a plan in anger on nothing but suspicion. Alas, thousands, through reckless rage, have perished and been turned to dust. So thank you.